Hi, favorite people. How are y'all doing? What a day here in Atlanta. Your girl is traveling. I have been back and forth from Boston and Atlanta in the past few days, and tonight is a historic day. So, we are going to talk about Boots. We are going to talk about Steve Sadow, and we are going to talk about Fanny. But before we do that, I'm also coming to you guys on a very historic day. Tonight, here in Atlanta, in the heart of Fulton County, we have two United States presidential candidates going to debate here in Atlanta. You have one, President Trump, you have one, incumbent, President Biden. The streets are closed. Um, Lead and I have been trying to game plan this all day because we love our community. And so many of you guys have been like, hey, are you guys going to cover the debates? We want to. But I guess this stream has to start with a note on free speech. CNN has threatened to sue any YouTuber or independent media organization, company, LLC, whatever, for live streaming the debate. So I have been following this all day because, I'm in Atlanta today. I flew down here today. And, part of this was in anticipation of a great opportunity to share this with you guys. And yeah, they are threatening to sue anyone that covers the debate. So I'm sitting here, in my What You Mean shirt. I'm ready. I'm ready to watch this with you guys. And they are coming at YouTubers specifically. So here's an example. There are a few YouTubers that are a lot bigger than me. They have subscribers in the millions. They have sued CNN because of this. It's censorship. It is, and you guys know, a lot of you guys that are in the chat right now, we have communities. We like to watch this stuff together. That's what we do with all these trial streams. You guys know it with the Young Thug thing that we've been doing. Trial streaming has become a thing where we've built community. Like, people like to watch stuff together and they like to get a breakdown from professionals that can explain what's going on, right? So thumbs down for CNN for doing this. I wanted to talk to you guys today, even on the road, even traveling. Part of me wants to just like go and sit in front of the CNN studio and live stream it from there. They won't let us stream. They won't let any YouTubers stream this. What you mean? And then on top of that, Lil Woody's wilding out today. We're not here to talk about Lil Woody. We're going to talk about Boots. We are going to talk about Steve Sadow and this 60-page document that I'm going to break down for you guys, if you're interested. But I mean, on a day like today, I can't not point out that First Amendment, even commercial speech for independent journalists or independent reporters that want to talk about like, it's not even talk about the debate. They don't want us to stream it. So it's almost like venture capitalism or like corporate America stepping in. Like, you want everybody to go over there to watch, but you don't want people to commentate. We're going to commentate. What you mean? We're going to commentate regardless. It's going to happen. So to threaten to sue people as a broadcaster, I just think it's a terrible thing to do. I side with all the YouTubers that are speaking out on this, but I wanted to start this day in Fulton County. It was just raining. Now it's sunny. I needed to start the day with explaining that to you guys because we were really looking forward to doing it with you together. All of y'all that watch, all of y'all that support us. It's just super, super unfortunate, right? Anyway, I want to thank a few folks that have sent me what Lil Woody was doing today. He took it down. I'm gonna read it to you because we are not in court for the Young Thug trial today and tomorrow. We're back on Monday. You guys have been watching the streams with us. That's been fantastic. But Lil Woody, he's wilding out, guys. Like, I'm not even gonna lie. He's deleted some posts. I have a copy of it here. I'm not gonna show it on the stream. But basically, earlier today, Lil Woody threatened his new people that watch him. He said, "Stop recording me when y'all see me out. Don't run up on me." And then he put it in parentheses, "For y'all's safety and mine." End parentheses. "This internet is a joke. I'm not a friendly person, and I don't hesitate. And for the police, I ain't hiding." This is it. This post has been deleted. Lil Woody Wildin Out. He's out there threatening people. So hiring, I'm working with folks. I'm working with my editors. I'm trying to put the narrative together because I really do not think that this man should be talking about this case online at all. Okay, you went from 23,000 followers on IG. Now you're up to like 89,000. But if people, Atlanta's small. Atlanta is small. It would be nothing. Like, sometimes I'll be hanging out with like Lead or other creators. We'll be at Lennox or something, and people would be like, "Oh my God, Lead Attorney." And then I'm so small. They're like, "Oh, and you're that girl that helps him." I can't tell you how much I hated that until one day I went to like a car wash, and a woman came up to me and she's just like, "Hey sis, you're AV." And I was like, "I am." That was like, I was so appreciative of that moment. Anywho, we'll see what happens with the presidential debates tonight. But just know we are on standby to see what's going on. If we can stream it, we will without getting in trouble. Just know we wanna watch it with y'all. So, I'm letting my audience know I want to watch it with you. How fun would that be? And are they doing this to protect Joe? He's been in Camp David for like the last week. It's like, "Joe, where you at? We got this border shit going on. What? Joe? Uncle Joe, are you there? Are you alive?" You gotta wake up. Come on, man. We don't have time. Uncle Joey. And this is not making fun of him, because even on the Trump side, there are some things that happen on that side too. There's always some things. But the truth of the matter is, we want to watch this with you guys. And First Amendment, freedom of speech, freedom of press, freedom of decorum is being suppressed right now. So if we can bring awareness to y'all, that's what we're doing. So Loretta said Biden 2024. Shout out to Loretta. Somebody said CNN is evil. I don't disagree. Why would you? This is an important day. They're shutting down streets. I'm stuck in the little radius. We can't go anywhere. The hell? Like, I was like, Lee, should we just stream from our phones outside of CNN headquarters? Because that's the thing. A lot of people don't know that CNN actually has a headquarters here in Atlanta, Georgia. And I believe that's why they're hosting this here. Here's the other thing. With the two candidates, they can mute their mics. Because you know Trump. Trump's going to talk. If he just got convicted and this is the first time that he can actually speak, Trump is going to speak on the mic. Like when Joe's thinking of what to say, when he's got the earpiece in, the earpiece in, and they have to help him with what to say. And Maybe that's why he's been in Camp David for 7 days to prep for this. But whenever I tell you guys what I'm really thinking, and people are like, oh, you're really just a mean person. I'm just me. I'm just a nerd in my Princess Leia buns, like you guys watching this stuff, trying to figure out what's going on. I just bring you some legal commentary in the process, right? Anywho, I needed to start with that message. How are y'all doing? Let's come to the chat. Hi, beloved chat. How are y'all doing? Who's in here? Who was first? Tay Biz. He says, Pitbull Sadow been on a rampage lately. He has. Shout out to Steve Sadow, guys. He is Trump's lawyer, and the case with what has happened, the Georgia election case here in Fulton County. Before Lead and I were covering Young Thug, we were actually covering this particular case because we were both, Lead lives here. I am in the process of moving out of Fulton County and going back and forth between Boston and Georgia. So for us, being locals, we had a unique perspective as taxpayers, and that's why we were really interested in the case. The whole thing with Fani Willis, Nathan Wade. My editor is working on a video for you guys on that. I did some pretty deep research on his media appearances that just so happened to start like a month ago. He's resurfaced. He stepped down in March. April was super quiet. Lead and I had an opportunity to talk to his divorce attorney because, again, he's not a free man yet. He's not fully divorced, and his wife that he's still married to right now is going through some serious medical concerns, serious medical conditions. Along the lines of, I don't want to say it, but like the C word. She needs to explore some of those things, and she can't because she's a homemaker, and Nathan provided a majority of the household's money and the household's income. But he also agreed in January, before all of this blew up, that he would cover a majority of medical expenses, things of the like, since he stepped down. And remember, he signed that in January. Since he stepped down in March from his post at the district attorney's office, Joycelyn Wade is still not able to get the medical care she needs. So we can talk to Marlon Wayans, and Marlon Wayans could throw his legs up in the air, but all of that's fun and games. But regardless, if you've been married to somebody for a really long time, and if they have some medical stuff, I know finances could be tight sometimes, but I think the right thing to do is figure out how we're going to take care of that, not just allow her to figure it out, So, anywho, that's my commentary on Nathan, but we have a video coming out on the Nathan thing. And this is just coming from a PR perspective. I got to be careful on YouTube these days because, you talk about one person and people are like, you're awful. I hate you. Go away. And it's just really? Can I say anything without people getting pissed off? I don't know. I give you guys a double bird. I just have to keep it real. Hi, Lashane. I haven't seen you in a while. Thank you so much for supporting me. Hard Body, the last time I saw you was super, super nice. Hi, Lashandra. She says, how about everyone hit the like button on the way in? Please do that. And before I do, and before I bring up, where is it? Because I have it right here. Let me bring it up. I'm going to bring up the actual legal document because it's a lot for us to look at. It's not too much, but I do want you guys to see the timing of when this comes out. So, State of Georgia, Court of Appeals, 1, Donald J. Trump, appellant, the defendant, against the state of Georgia, the plaintiff. Now, what is this? And let me explain it a little bit. We've talked about this case for months, and we know that Nathan and Fani had what appears to be an inappropriate relationship. He was paid well more than other individuals that worked in that office. You know, you guys see the performance and the YSL case. You have DA Love. You see folks like Simone Hilton. You see people that are really working hard day in, day out. Nathan, not saying he didn't work hard. He was an independent contractor, didn't necessarily work for the office, but he had this personal relationship with Fani and had a very high salary that I'm sure most of us that don't make that amount in a year would love to have $700,000. But what does it cost you? What do you need to do? What do you need to do to make the 700,000? So you have that. Right? It's super interesting. This document is about 62 pages. Of course, I'm not going to bore you guys through all of it, but I do think that there are some interesting things included in it. And Steve Sadow filed this about 2 days ago, and he's Trump's lawyer. 2 days ago, debate week. This case has been stayed until after the election. However, the Court of Appeals in the state of Georgia has agreed to listen to opening arguments, to listen to opinions on October 4th. So even though they froze the case, so to speak, they are still going to listen to arguments. They're going to listen to all the Trump defendants on that side, because all 6 or 7 of them want Fani Willis disqualified from the case because of what happened with Nathan. There's other things in here. We're going to go through the church speech, guys. You guys remember the church speech on MLK Day in Big Bethel, right? We're going to talk about all of those things. So I'm going to review that with you, but I do want to come down to the chat and say hi to folks. Shout out to Nurse Janice across the pond in the UK. 6 hours ahead. Janice, what time is it? Janice? Should you be getting sleep as a nurse, Janice? What's going on? She's one of my faves. Had to give her a little bit of a hard time. Love you, Janice. Hope you're having a great night. Shout out to Higher Thinking. He says, salute AV. Do Work says, what you mean? And this is one of the reject shirts, guys. Like, if y'all want that merch, I don't have it in the link to the description box. Give me a few minutes. I'll put it in there after the stream. It will be included. But yeah, we have What You Mean merch. This is one of the rejects where it's the hashtag What You Mean. So it says TLAAV. I'm going to try to surprise him. I'm spoiling the surprise, but while I'm down here, I have one for Lee too. So we're going to give him the reject shirt. Hashtag reject shirt. Good to see UFO in here. Harlan's in here. Hi, Tony. Annie's like, I love your hair. It's so cute. Yeah, I'm running out of things to do with it. And it's kind of humid here today. There's a little bit of thunder. So I have to rock with the weather. Shout out to Art of War. Captain Teach is in the building. He said, AV, my love. Vanessa, hi, Vanessa. She says, hi, AV, Trump 2024. A lot of you guys are thinking of voting for Trump. This is cool. Shout out to Joe Townsend, Joey Crack. I don't want to call you that because I don't know, like, you know what I mean? Like, I don't want to go too northern with you, but shout out to Joey, huge supporter of mine. Hi, Eric. Abba's Child's in here. Eve is in here too. She says, Miss Sylvia is live, and she says Weinstein's motion has been denied. Eve, stop. Hold on. Sorry, guys. This is breaking news if it's true. Georgia Supreme Court. I'm going to go. You guys know I check the docket every day. I showed you how to do it yesterday. We're going to check by party names. We're going to type in Glanville. Oh, shit. Shout out to Eve. If y'all could type Eve in the chat right now. Share this tab instead. Okay, we're going to YoungThug for a moment. We're going to YoungThug for a moment. Here we go. Y'all ready? Supreme Court of Georgia. Diamante Kendrick versus Oral Glanville, Chief Judge. Right? Case status, it was docketed. This now says judgment. As of 3:04 p.m., a motion has been filed. Well, no. Hold on. Let's go to judgments. Oh, it says dismissed. It says dismissed as of today. Judgment line, it says all justices concur except for Peterson not participating. Oh my God. They denied. Thank you, Eve. And it looks like I'm going to validate what Miss Sylvia's reporting is accurate. I'm showing it to y'all. The Supreme Court in Georgia has denied Doug Weinstein's motion to have Judge Glanville recused from the case. I want to look at the opinion. I'm going to text Lead. We need to do a stream on that like tomorrow. We need to do a stream on that tomorrow. That's interesting. I wonder why they did it. I wonder why. All these defense attorneys in the YSL case wanted was for Judge Glanville to follow the rules. This week, he all of a sudden wanted to start following the rules. He was just like, oh yeah, I'm going to give you the transcript now. And it's just like, but why didn't you do that last week? You didn't give us the transcript last week. You're going to put Brian Steele in jail? We had a tenured attorney, I think it was Tate, tenured attorney Tate. I showed you guys his credentials. We went through that affidavit. He did such a great job explaining why he thought that judicial conduct existed, right? All of that. He thought that it existed. He did not think that Judge Glanville was ruling upon the book, right? We didn't see that happen. So I would love to see the opinion. I'm super curious now. So I can validate what Eve is saying here. And this is why I love this community. I love the chat. Like, you guys bring us information. But yeah, I'm pretty sure that they are going to issue a full document on that and for us to dive into it as well. Because I'm curious, like, why did you think that it didn't warrant it to be? And that's the thing. Just assign it to another judge. The Supreme Court gave Steele a win last week, but they did not give Weinstein a win on this one. We ain't even supposed to be talking about this right now. We're supposed to be talking about Fani. We're supposed to be talking about Fani. So Eve, thank you so much. I really appreciate you. Shout out to Audrey. Live stream the debate, AV. Like, you guys want to see it. Yeah, CNN did that, Tom. They did it. Jim's like, what you mean? Okay, I'm not even going to hold y'all. Let's get into business, shall we? We'll go into this document. Before I do, you guys know I have to shout out my sponsor, Aura. If you hate robocalls, if you hate them like the way I do, if robocalls happen to you, please check out the sponsor of today's stream. It's a company called Aura. They check you out on cyber. They will protect your data. They will actually reach out to data companies and make sure that they take your information off of their sites, things of the like, because your data is for sale. It really is. Every day, all day, your data is for sale, and companies will sell your data. Have you recognized that when you go to a lot of websites these days, it says allow the cookies or deny the cookies? What do cookies do on the internet? Cookies save your information, and data brokers will sell your information. So you could be sitting there signing up for a newsletter. You bet your ass somebody on the other side is saving everyone who signs up for the newsletter and can sell your email addresses and your personal data to someone else. Check out Aurora. 14 days for free, $14.99 a month. At least I'm helping you out with that. All right, check it out. Check it out in the comment section or the description box after this. Let's get into Steve Sadow's document. I really can't believe the whole Supreme Court thing. Thank you, Eve, for bringing that to my attention. All right, guys, let's jump into this. So on debate night, since we can't live stream the damn debate, we are going to look at a Trump document that was filed earlier this week. Again, this is scheduled to be argued on October 4th, but will not be decided by the state of Georgia, the Court of Appeals until after the election on November 4th or 5th. All right. So you might see some action on this case heating up in December. Steve Sadow, Trump's attorney, filed this. It is in response to Fani Willis's office wanting to have this case dismissed. She wanted it dismissed from the I'm getting confused with YoungThug, the Court of Appeals of Georgia, which is the layer underneath. That's where this case is right now. Unlike Judge Glanville, Judge McAfee, who presided over this case, a cool 34, he's same age as me, looks a little bit older. But shout out to Judge McAfee. He actually was lenient on this one and allowed this case to go up to the Court of Appeals by granting a certificate of immediate review. So this is Steve's response. This is what he's going to argue. Let's check it out. It's pretty cool. So this is the opening brief for President Donald J. Trump, right? So we have Trump stuff here. We have Steve Sadow, and we have his law partners, Jennifer Little and Matthew Winchester. And their oral argument has been requested for October 4th. Now, when it comes to appeals documents, here's where things start to look a little bit different from what we typically show you guys. It's not just a complaint, right? When you appeal something, your argument needs to be super freaking clear. It needs to it's almost like a book. You see the table of contents, you see a table of authorities. Now, a table of authorities is like a listing of all the cases you're going to use. Typically, attorneys will put it at the very end of a document and go from there. There's a statement regarding the co-appellant's briefs. So again, the president is leading this, but there are 5 to 6 other co-defendants that, some of their statements are going to be included in this too. We talk about jurisdiction here. This is the election interference long ago here in Fulton County. So of course it is going to be presided here in Georgia and things of the like. Now, Steve has broken this out. It looks like it's in 3 parts. Yep. So when we break out arguments, guys, they usually do it. And when you're doing this in the Court of Appeals, you need to do it in a way where it is easily referenceable, meaning that you need to be almost like a book, like a small little book or a dictionary. You want to be able to go to the section where something was there, right? And the way that they've laid this out, it looks like there are 3 core arguments. The first argument is really centered on the course of proceedings below. They want to give you the facts and they want to give you the procedural background. The facts are, that's where they're really going to talk about the Fani things. And then the procedure is really what happened when the judge ruled upon certain things, right? Because essentially they wanted Fani off of this case. They did not think that the relationship was appropriate. They didn't, and when these procedural hearings happen, because we're not at trial yet with this case, when these hearings happen, they gave everybody an opportunity to talk about this. They interviewed Nathan, not even interviewed. Nathan was on the stand. Fani was on the stand. You saw Ashley Merchant really spearheading this. Shout out to Ashley to expose the corruption. How did she get information? She got information from one Terrence Bradley, who was Nathan Wade's law partner. And Nathan Wade's law partner was singing like a bird to Ashley and shared everything that happened. Shared that they have been involved and that they had this relationship for years. Shared that they would, go on trips together. Shared that Fulton County taxpayers were paying for those trips. Shared that a lot of these things were going down. Nathan was doing all this while Joycelyn, his wife, was at his house, at home, still living there. He claims that, they wanted to wait. They had an agreement. They wanted to wait until the kids were out of the house and can go from there, right? So that's why this happened. They had an agreement and he was free to do what he wanted to do. Anywho, back to the document. Part 1 is the course of the proceedings. Part 2 is the error itself. When you come to the Court of Appeals, you have to tell us what the judge did wrong. What did the judge do wrong? Right? So that's what we're going to see on page 19 down here. And then part 3 is the argument and citations of authority. So Steve is making this very easy. Number 1, let me brief you on everything that happened. Number 2, let me tell you where the judge made a mistake. And number 3, let me tell you on behalf of President Trump what our argument is. Notice that you see like up here, everything's super clean, like A and B. A, factual background. B, procedural background. Go to part 3. When you get to the argument, you see what lawyers do? You see all of this. You see all of this up here. So he starts to break it down with his argument, and he says, 1, the trial court, Judge McAfee, made a error in his holding, in his decision, that the standard for forensic misconduct prohibits a trial court from disqualifying prosecutors for intentional and deliberate violations for the Georgia Rules of Professional Conduct. So he's basically saying that Judge McAfee made a decision there, and that decision was wrong. And particularly, it is interpreting what forensic misconduct means. He believes that Fani has done that. There is forensic misconduct here. He believes that Nathan has done that. But it's not even just a solo belief. It's under Georgia law, right? And you have to disqualify prosecutors in the right way. But when they have intentional and deliberate violations, we have to look at those violations and where are those rules coming from? They're coming from the Georgia Rules of Professional Conduct. That's what governs attorneys. Now, you have 1A, you have 1B, you have argument 2 and 3. So Boots has about 3 arguments here. Let me go under disqualification because I think this is interesting. Y'all gonna love this. The trial court truncated the analysis of whether DA Willis's forensic misconduct was part of a calculated plan. So he's got like 4 pages on that. Here's why it's an issue. 1, Fani Willis said that she was ordained by God. Okay? In her church speech, she casted racial aspirations towards the defendants and defense counsel. They got 3 pages on that. Next, prior extrajudicial statements to the media evincing Willis's opinion of the defendant's guilt. I don't know if you guys remember in April, a few of us were following Fani's news, her news appearances. You know, she did one around Easter locally here in the Fulton County area, and she has a right to do that. She's the DA. She should be doing those things. She should be out in the community. But if they're catching you at an Easter egg hunt, is it appropriate to kind of make a statement on this case? Why do you think they're following Nathan everywhere? He was on CNN like 2 weeks ago and they pulled him off air. They're like, you need to get off of the screen because you're talking about the Fani thing and you shouldn't be. Why didn't they do that with her? I don't understand. Next, they talk about Find Me the Votes. This is a book, right? It is a book that other people wrote. In fairness, Fani did not write this book. Find Me the Votes is a book, and she participated in helping the authors craft it. What is the book about? It's about this case. And Fani sat down with the New York Times best-selling authors that published and wrote this book. Is there something wrong with that? No. But here's where I'll give you the other side of it. It is an ongoing investigation. I think, in my opinion, it's probably more appropriate for you to talk about the case when the case has concluded. Not while it's ongoing, not while there's a grand jury impaneled. As a DA, I am going to take a few points away on this one, because I do think she should have waited until after you, and there's nothing wrong with it. You can comment to the public, but there is an ethical rule when it comes to publishing. So for example, we can go back to OJ. You guys remember the OJ case. How many attorneys and people were involved in the OJ case? Some people wrote books. Some people published books. Some people made money off of those books. But did it happen after the case had concluded, or did it happen during? You see a big issue, and I'll give you a comparison. Murdoch, the whole Murdoch case in South Carolina. Oh man, that's a whole nother one. The Murdoch case in South Carolina. Becky Hill worked in the court. I think she was a court reporter. She wrote a book. She's not a party to the case. She's not a lawyer in the case. She was somebody that worked in the courthouse, and Becky Hill wrote a book and published the book while the trial was kind of ongoing. Right? And she knew so much. She was involved. She was walking with the jury to the scene of the crime, doing all these things with them, looking at their reactions. And shout out to Miss Sylvia, love her. But think about if Miss Sylvia was writing a book right now on the whole YSL thing. I'm just using that as an example. I'm not saying that she's doing it. But think about that. There's nothing against the law for people to do that. But when you're directly involved, when you're a party to the case, or when you represent a party in the case, or when you work for the court system and you're doing that for profit, this is the dirty game, guys. This is the dirty game when it comes to this legal stuff that you have no idea that happens. I was surprised in law school when I needed to study for the MPRE. I passed that one. It's another test in addition to the bar exam. Thank God I passed this one. But it's about ethics, and they test you on it. Lawyers, you can profit. You're going to profit when you're representing people, but lawyers, you can also profit by writing publications either after the fact or before, not before, after the fact. Look at Johnny Depp's lawyers. Camille, we loved Camille. Camille did her thing. Do you guys notice that, who shows up on Law and Crime all the time to talk about everybody else's case? Ben Chu. This is not a shot at Ben Chu. I think he's brilliant. But, attorneys do get paid for these media appearances too. So it's kind of all right, stuff about the case. There's some things you can say. There's some things you can't say. But was it completely inappropriate for Fani to be involved in this book at the time that it was going on? I would say I would have preferred for her to wait until the case had concluded. All right? That's my opinion. Next, they talk about her conduct when she was on the stand, the pink dress day, okay? It also talks about her submitting a false affidavit and false testimony in her attempt to conceal her misconduct. So that means, on the stand, talking about the Nathan thing, there are some contradictions. We found cell hawk data. She said no relationship existed before he got hired. Because the cell hawk data proved, and Steve Sadow hired a investigator that was able to get the cell tower information. And we were able to triangulate their location, and they would hang out at night, late at night, prior to him getting appointed to his role as special prosecutor on this case. Right? I don't have that cell hawk data in front of me, but Lead and I have analyzed it. We've seen it. It's been brought up in these court proceedings. So when Steve says here that she's trying to conceal her misconduct. That cell hawk information, that evidence came out after both Fani and Nathan testified. So it is a concealment, at least that's how it appears, right? He talks about a false affidavit here, so I do want to pull that. And then he talks about the false testimony, and that's what I'm referring to. And then there's evasive tactics. You guys know we were selling candles that was like, that was cute. You remember that was a cute thing. So argument one has so many pieces under it, but it really, the umbrella is the forensic misconduct and all those things I just explained. And I'll put timestamps on this afterward for those that are watching on replay so you can get through it faster. But this first umbrella is forensic misconduct. Let's go to umbrella two. Umbrella two is saying that the court, Judge McAfee, made a mistake by failing to disqualify both prosecutors upon finding the prosecution was encumbered by their significant appearance of impropriety. So Judge McAfee, and for those that are just kind of learning about this, when Judge McAfee made this ruling, he said one of them had to go. He didn't say that both of them had to go. He gave them a choice. So it was very impartial. He said, Fani, your office could stay on, but there is some impropriety here. There's an appearance of it. So Nathan can step down, or your office can step down, and we can assign this to a different county's office. You guys already know she was not going to step down from this at all. She was going to stay on. So Nathan had to go. And when Judge McAfee ruled and made his decision, I kid you not, me and Lead streamed it in one day. I kid you not. 4 or 5 hours went by, and Nathan Wade's resignation letter was made available. So he fell on the sword. He fell on the sword, right? So they're saying that McAfee made an error here because instead of taking both of them off of the case, he decided to keep one. So they're saying that that decision was not sound. It wasn't legal, right? So we'll see why. And then thirdly, it said the court, Judge McAfee, and refusing to dismiss for the prosecutorial misconduct outlined in sections 1 and 2. So they're saying, like, Judge McAfee, you could have ruled differently. We want the Court of Appeals to look at this, but we're also saying because you made this mistake, that's section 3. You didn't apply forensic misconduct correctly. You didn't disqualify both of them. And thirdly, by failing to dismiss this thing, we're now looking at you as a judge and the decision that you made. So it's a 64-page document. Of course, we're not going through the whole thing, but I'm going to point out the important parts. So here's an example. I'm just teaching you guys because I like to do this. Table of authorities. These are all of the cases that they have cited in this brief. You guys know if you've been to college, you have to cite your sources. Same in the law. If we say something is illegal or something is a part of a law, we need to tell you what case we're using, where we got that from, what year it came from. So like, look at this. Boots is using a 1935 case, but it's a Supreme Court decision. That means it's what everyone uses. There's a 1965 case, 2017, 1966, 1988. But notice how in this table of authorities, he's going to tell you on what page it is. It's almost like when you open a book and a dictionary and you tell everybody what you're using. You got to cite your sources. And this is in, it's almost like in a cadence or, a pyramid or a hierarchy. Here's all the Supreme Court decisions he used. Here's all the United States Court of Appeals decisions that he used. Then he goes down to the state level. Here's the state constitutional provisions he used, Georgia law that he used. You see how these become cumbersome because it's like 3 or 4 pages of, a primer. Then he goes to the rules of professional conduct. He went to the American Standard, so the ABA, the American Bar Association. He went to Fulton County itself, and then he went to the state of Georgia. And then he's got some secondary sources. And then he has a statement up front telling you, hey, 9 appellants, 9 people that were involved in this Georgia interference case, these Trump defendants. There's 9 of us. We're agreeing. We're working on this together. And the issue at the trial court's refusal to disqualify Fani Willis and dismiss the case for this misconduct. So Steve is actually leading the pack here. He's coming out and saying, all right, is 9 defendants. We're a part of the RICO. The same way that YoungThug and team are a part of the RICO, but us 9 defendants are coming together and filing this jointly, right? So they're coming together to do that. Each appellant has their own docket and must file their own brief. President Trump intends to adopt arguments made by his co-appellants pursuant to Georgia law. Because this rule adoption of other appellants' arguments with precision, President Trump does not yet know each argument by enumeration of error that his co-appellants will raise on the disqualification issue. He intends to file a more detailed notice of amended statement of adoption upon reading the briefs of his co-defendants. So basically what Steve is saying here is that the Trump team decided to file first out of all 9 people. They wanted to make sure that they're filing their brief first, and this is coming as a first one, and that he will be willing to adopt some of the statements that come from the other people that are being sued as well, because they're all defendants collectively in a RICO. You're all collective defendants, but every defendant has the right to file their own petition. It's like me and you, Vanessa, or Michael, or Shy Girl, right? Oh my God, no Black media is allowed at the Shy Girl, stop. I will go up there tonight. It's like if the 3 of us were co-defendants, Shy Girl's going to have her lawyers draft something and she's going to be like, listen, these are our arguments. And then Vanessa is going to be like, okay, well, these are our arguments. And then Michael's going to be like, these are ours. Collectively, as defendants, we can, file everything that we want to do individually. But at the same time, Vanessa's brief might have something that maybe my lawyers didn't see, or an angle that we weren't going to strategize on. But that's good, So in a way, when it comes to RICO, a prosecution team will attack you on RICO up front. They'll come to you and they'll say, hey, group of defendants, you organized crime people, we're going to attack you with this. The beauty of this is that on appeal, or when it's a time to attack back, you are getting attacked by like 9 lawyers at the same time. It's like, is it smart to do this? Is it? So that's what we see here. Moving on, it says the amended statement of adoption will significantly include the arguments by reference to the enumeration of errors and arguments contained in the co-appellants' briefs. As of this filing, President Trump hereby adopts the following arguments. Here it is, which he is presently aware of and he has reason to believe will be advanced by his co-appellants in the related interlocutory appeals. Michael Roman, enumerations of error and argument challenging the court's determinations of actual conflicts of interest and the appearance of impropriety. Dave Schaefer, enumerations of error including and argument challenging the court's proposed remedy. See what I mean, guys? You see how these are going to be slightly different for all the defendants? And B, forensic misconduct, and C, appearance of impropriety. Robert Chile, enumerations of error, argument challenging the court, failure to determine an actual conflict of interest existed, and failure to disqualify D.A. Willis. Robert wants her. Notice up here, you didn't see Schaefer go for that. Robert wants her specifically and says, after determining an appearance of impropriety existed. President Trump also adopts in their entirety the co-appellants briefs filed in for Mark Meadows, Kathleen Latham, Rudy Giuliani with his hair, Jeffrey Clark, and Harrison Floyd. Here's a statement of jurisdiction. I'm not going to go through that. They have jurisdiction over this case. They know they do. Okay, part 1, course of proceedings below. This all-important appeal presents a novel issue concerning the legal standard for forensic misconduct, warranting dismissal of an indictment and alternatively the disqualification of a prosecutor and her office. Below, the trial court found that elected Fulton County District Attorney Fani Willis gave a prepared and legally improper speech about the defendants and the significant appearance of impropriety existed. But they stopped short of ordering remedies that these findings required. In so holding, the trial court failed to accurately apply the forensic misconduct standard and thereby abused its discretion. So here's what's happening. Steve is like, listen, Judge McAfee, you saw what we saw. You saw all the evidence that we put in front of you. You saw all 9 of these defendants say the same thing. That relationship between her and Nathan was not okay. It wasn't cool. Some of these people are literally in jail. Some of these people have done time. Some of them have bailed out. It's this RICO thing. We want to focus on that. All good. These are the charges. But you saw what we saw. You also said yourself, Judge, that this was an appearance of impropriety. But what happened, Judge? You didn't necessarily act with the power that you should have acted with. And to take it further, we know what forensic misconduct means. We've pulled all these laws and we've done all this research to prove to you what forensic misconduct means. And we didn't apply it correctly. Or you didn't apply it correctly. You still gave Fanny a chance. You still gave her a chance, and that's okay. Should a prosecutor be disqualified for intentionally and repeatedly violating ethical and professional canons to prejudice defendants for personal or political gain? Yes. Is disqualification necessary when a prosecutor testifies falsely, conceals misconduct, and creates an odor of mendacity that results in a significant appearance of impropriety? Undoubtedly so. If this prosecutor deflects attention from her misconduct by claiming on national television that the defendants are dishonest racists for bringing the truthful accusations to light, could anyone have confidence in the impartiality of the prosecutor's actions? Absolutely not. Since launching the investigation, DA Willis has engaged in a pattern of consistently flouting her ethical obligations, which has resulted in her being publicly chastised and twice disqualified by 2 superior court judges. Because neither fully removed her, Willis has become emboldened. To this day, Fanny continues to ignore those clear warnings without remorse or accountability, making it crystal clear that her previous improper conduct was neither inadvertent nor isolated and was both planned and part of a long-standing wrongful practice. Steve Cookin. This is like a book. Steve Cookin. He said, Willis has put her personal, financial, political, and romantic interests before not only her own professional integrity, but more importantly, the due process rights of the accused. and the integrity of our judicial system. Willis has taken full advantage of her position to poison the well for the defendants. Willis believes she is immune from disqualification, regardless of how unethical and outrageous her comments are, so long as she does not, in her view, explicitly state that a particular defendant is guilty of the crimes charged. This is not and cannot be the law. The trial court's order expressly found that Willis's challenged actions, including hiring as lead prosecutor her paramour, Special Assistant District Attorney Nathan Wade, and accepting gifts and trips that were funded through his taxpayer compensation, created a financial cloud of impropriety that cast a pall over the proceedings. The order determined that Willis's out-of-court speech was legally improper. That's exactly what Judge McAfee said. McAfee did say that her out-of-court speech was legally improper, that her conduct at the disqualification hearing was unprofessional, and that the significant sworn testimony from her and Wade was both dubious and likely false. That's why he's putting this in front of the Court of Appeals. The judge said that himself. Dubious and likely false. What does dubious mean? That's one of those crazy words. Define dubious. Webster defines dubious as an unsettled opinion, doubtful, meaning here that Judge McAfee in his ruling said that he knows that they are likely lying, both Nathan and Fani. They are likely lying. McAfee was required to unequivocally disqualify Willis in her office. The proposed remedy that he suggested? A forced election between the withdrawal of Willis in her office or the withdrawal of Wade. He gave them a choice. He said one or the other. He didn't say both. And what Steve is saying here is that when you do one or the other and not both, you don't fix it. You did not redress the appearance of impropriety, nor did it cure or mitigate the misconduct or the odor of mendacity that it found permeated in this case. The Supreme Court of the United States has long recognized that the public's faith in the integrity of the criminal justice system is critical to its functioning. He's using a 1935 case there. Courts have an obligation to ensure that legal proceedings appear to be fair to all who observe them. Right? You guys are watching. Did you think, we're going to do a poll. Did you think that Judge McAfee giving them a choice was fair? You could put a 1 in the chat. Or did you think that Judge McAfee not disqualifying both was fair? I'm really curious to see how you guys feel about it. 1s and 2s, let me know what you think. And I'm going to pop in and move on here. But I'm very curious to see how you guys think. He has a quote about justice here from a 1965 case. He then goes on to say, nowhere are these interests more important or on display than in a high-profile case involving a former president of the United States and presumptive 2024 Republican nominee for president that has captured the attention of our nation. This is why this was dropped on Monday. Shout out to Steve. Shout out to Steve. Did y'all see that? 2024 nominee. When was he? When? On what date? Let's look it up. On what day was Trump announced as the 2024 nominee. Okay. So he announces that he was going to run. Everybody's talking about the debate right now. Chat, if y'all could find that for me, that'd be great. I would love to just mention when he was formally announced by the Republican Party, like that day. I think that would be really important. If anybody can find it. Sorry, I'm super unprepared. I wish I had all my screens and could do this, but let's keep going. Crucial to the public's confidence is that a prosecutor remain and appear to be disinterested and impartial. The prosecutor has more control over life, liberty, and reputation than any person in America. Wow. That is an enlightening statement. The prosecutor has more control over life, liberty, and reputation than any person in America. Think about that whenever any of us are defendants or people we know are defendants. It says, make no mistake, Willis, by persistently untethering herself from the legal, ethical, and professional constraints of her powerful position, has decimated the integrity of these proceedings. Sadly, the circumstances that require her disqualification are entirely self-inflicted wounds that were within her power to avoid. Ooh, here we go. DA Willis disqualified herself. He put that shit in italics. Absent the removal of Willis in her office, an appall of the order of mendacity will continue to loom. To give effect to the professional conduct rules and protect defendants' due process rights, this court must conclusively disqualify Willis in her office and dismiss the indictment. Now we go to facts. That was strong. Wow, Boots went in. Okay, here's his facts section. On January 8th, Michael Roman moved to disqualify Willis, and this is through Ashley Merchant, and her office based on the personal financial stakes she acquired through the secret relationship with her lead prosecutor. The Roman motion alleged that Willis hired Wade, paid him approximately $650,000 in a 2-year period, and had personally and financially benefited from this relationship. Evidence revealed that from October 22 to April of 23, Wade incurred over $17,000 in credit card charges for vacations that he and Fani took to Miami, Aruba, the Bahamas, and California. Fani admitted that she was the recipient of the day trips to Tennessee, Alabama, South Carolina, North Carolina, and other parts of Georgia, and had numerous lunches and dinners. These expenses were neither shared proportionally nor tracked. Willis could only produce a single receipt for plane tickets totaling $1,300 in her effort to offset the $17,000 paid by Wade. The other interesting part about this, guys, is when they questioned them about this relationship, when they were trying to hide the relationship, when we were trying to track the $17,000, like how was that spent? Did it come from taxpayer money? Because here's the thing, Nathan Wade gets paid. He gets paid by the state. Fani, we've discovered through Georgia House of Representatives and the congressional hearings, we learned that Fani can just go to the government and ask for money, and they would just sign and give her whatever she wanted. There was no oversight. So nobody was ever checking this. We learned that. So we're seeing Fani go and get this money and pay Nathan. But Nathan was an independent contractor. That's their big argument for their relationship, is he was an independent contractor. He never was employed by the state. So because she needed extra help at the prosecution's office, when I don't understand, there's like 200 people that work there. Atlanta's not, I'm looking at it, it's not that big. It's not that big. Boston's bigger. New York, Lord knows, is bigger. Metropolitan, there are so many bigger cities than this one. But I'm looking at it, it's not that big. So you have 200 people at the prosecution's office, but she did have a giant, I'll give her credit for this one. She had a giant backlog of cases from the prior regime that were just not solved. So they needed help. But if you're going to take on the election interference thing, if you're going to take that on, that is going to take a legion of attorneys to help you. So she had to outsource. I already knew Nathan. I already knew him. I wish I had my soundboard. She knew Nathan. And thought that this man who had not tried many or presided, because he was a former judge, he had not done a lot of criminal work compared to other candidates in the past. There were plenty of qualified people out there that could have taken this job, but someone like him that had not the best qualifications for a case like this was appointed. She appointed him. Special prosecutor, but independent contractor, was paying his law firm, right? Why did I mention cash? Because cash doesn't leave a paper trail. You guys know that. That's why drug dealers use cash. Like, pay me cash. And it came down to, Fani, where did you get all the cash that you have? Why are you always paying him in cash? It's kind of uncommon. Most people use cards. Most people use things that have paper trails. What is the deal with cash in 2023, in 2022, in 2021, in 2020? Why did you choose as a person to pay with things in cash? Doesn't mean that most people don't do it. It's just kind of becoming less uncommon. I'm also saying that to you guys as a person that has been in the banking industry for 15 years. Cash is abundantly becoming less common. Some people keep cash under their mattress. There are those people out there, and you might be one of them, and I'm not offending you. It's okay. Fani claims to be one of those people that keep cash under the mattress, in a box, I don't know, in a safe. And when she was questioned on how she came about these large sums of cash, and we're all at home like, what you mean? Huh? Say it again. What do you mean? Where did that cash come from? It came from Publix. We all go to the grocery store. We got to buy food. You go to Publix, I go to Publix. Maybe it's Stop and Shop in the Northeast. Maybe it's another grocery store. Maybe it's Kroger. You go to your grocery store, swipe your card, and you do it at Target too. Would you like cash back? Fani said that she hit yes to those buttons and was like, yeah, I always take cash back. I always have cash. A man is not a plan. I take care of myself. My daddy taught me that. Nothing wrong with that. Not making fun of her. Just saying this is what was said on the stand. Okay? That's it. Let's keep going. So we see that Steve Sadow and team wanted to start figuring out where this cash was. Where did this $17,000 come from? Because really the core intention behind that question was to see if it came from taxpayer dollars. They didn't want to answer it. So I think that's where the cash narrative came from. Anywho, Wade testified that expenses were paid on his cards because, for safety reasons, she would want to limit her transactions. And he explained how they were unavailable. They were unable to walk through the airport or sit at a restaurant because of all the attention that they received. No evidence suggests that her bank accounts or credit cards were ever mentioned, however. So Nathan is saying he always paid for stuff on his card. He paid for stuff on his card because he wanted to protect Fani. They had high-profile jobs. Everyone in Atlanta, like I said, it's small. Everybody in Atlanta knew who they were. If you're a defendant and you have a bad situation with them being tried by the prosecution's office and you see them out and about, I'm pretty sure they got negative attention. I'm not going to discount that. However, it says here, long before the Roman motion was filed, Willis had engaged in a pattern of conduct designed to prejudice defendants for personal gain. Beginning 2 days after launching the investigation and continuing abating to this day, Fani has made widely publicized extrajudicial statements to the media regarding the defendants, and this case, despite her heightened ethical obligations to refrain from doing so. Fani was previously disqualified by a judge 2 years ago, Judge McBurney determined that Willis had created an actual and unintendable conflict of interest by publicly naming Lieutenant Governor Jones as the target of her investigation and then headlining a political fundraiser for his opponent shortly thereafter. What is that? You see that right there? That is an example of Fani in the past using the media to get something done. Using the media and saying whatever she wants in front of the media, that's her choice. But there's also a pattern here of doing it. You guys know neural pathways. When we make decisions to do things in a specific way, it creates a neural pathway. And if you do it enough, it becomes a pattern. Behavioral patterns. Steve brought this up because this is a behavioral pattern. Judge McBurney then took the unprecedented step of carving out the target of the investigation rather than the conflicted counsel. So here he says, all right, I saw Fani did something wrong, but I'm going to take the target of the investigation out rather than Fani herself. 4 days after Roman moved to disqualify, the trial court noticed that the parties of its intent to hold an evidentiary hearing, in spite of the impending disqualification hearing, Fani undertook additional efforts designed to prejudice the defendants and deflect attention away or otherwise conceal the full scope of her disqualifying conduct. 2 days later, here comes the church speech. While facing intense media scrutiny, Fani, during the Martin Luther King holiday weekend, gave a keynote speech at Big Bethel Church, a historic Black church in Atlanta, knowing this speech would be covered by local and national news media. With a notebook of prepared remarks, Fani marched to the podium and continued her premeditated pattern of prejudicial public statements about the defendants and their lawyers. This time, however, in her zeal to protect her personal interests and reputation, she upped the ante in 4 ways. Oh, Steve's going in. Number 1, Fani falsely maligned defendants and their counsel as dishonest and claimed that God told her to pray for their souls, deflecting from her personal relationship with Wade. Second, Fani injected race and racial bias into the case while referencing politics as a red herring when she knew the misconduct allegations were true. Third, Fani strongly intimated the defendants were guilty and would be convicted, boasting that her superstar team, with the conviction rate of 95%, was a win-win-win. Fourth, Fani appealed to religion by implying that God had chosen her for this case, was on her side, and that she was doing God's work by prosecuting the defendants. And one of the defendants, including a former American president. D.A. Willis said, "Why does Commissioner Thorne and so many others question my decision in special counsel? Lord, you're flawed, hard-headed, and imperfect child. I'm a little confused. I appointed 3 special counsel as it is my right to do. I paid them all the same hourly rate. They only attacked one. I hired one white woman, a good personal friend and great lawyer, a superstar, I tell you. I hired one white man, brilliant, my friend, a great lawyer. And I hired one black man, another superstar, a great friend, and a great lawyer. Oh Lord, they're going to be mad at me when I call them out on this nonsense. First thing they said, oh, she's going to play the race card now. But no, God, isn't it them playing the race card when they only question one? Isn't it them playing the race card when they constantly think that I need someone from another jurisdiction and another state to tell me how to do a job I've been doing for almost 30 years? God, why don't they look at themselves and just be honest? I mean, they can't keep it with themselves. Why are they so surprised that I have a diverse team that I assembled? Your child can accomplish extraordinary things. God, wasn't it them who attacked this lawyer of impeccable credentials? The black man I chose has been a judge for more than 10 years, run a private practice for more than 20, represented businesses in civil litigation. I ain't done, y'all. Served as prosecutor, a criminal defense lawyer, special assistant attorney general, won Chief Justice Rob Burham Award from the State Bar of Georgia. You know, they ain't just giving this to black men. How come, God, the same black men I hired was acceptable when a Republican in another county hired him and paid him twice the rate? Oh, y'all like to hear me. In another county, the elected official has the authority to pay him twice the rate. Why is this white Republican's judgment good enough, but the black female Democrats is not? Now, please hear me. I'm not criticizing his judgment. The people of this county elected him to make that decision. In fact, let me put it on record. He's someone I respect because he always is willing to hire diversity. He was just looking for quality. I don't care. Political party, I think she meant to say, I don't care about political parties. They care about it. My only question is, why do they question me? Why do you question Fani? Chat, tell me. Why? Now, I want to be clear. All three of these special counselors are superstars, but I'm just asking God, is it that some will never see a black man as qualified, no matter his achievements? What more can one achieve? The other two have never been judges, but no one questions their credentials. I'm just saying, Lord, I'm just asking, is it that I, because of the shell you chose to put me in, will never be qualified in their eyes to make the decisions the voters put me here to make? Oof. Lord, never mind, your flawed, imperfect servant has composed a team that wins and wins and wins. Never mind, Lord, that this leader has a trial conviction rate of 95%. Never mind, Lord, that the trial team that this lawyer put together has a conviction rate of 95%. Never mind, Lord, that the appellate rate of my office is 96%. Never mind, Lord, that this 400 plus children are touched by the programming that my staff put together to keep them out of gangs. Never mind, Lord, that thousands of records of citizens in my county have now been restricted so they can work, get home, and return to being productive. Never mind, Lord, that in 3 years I have cut the backlog by more than 50%. Never mind, Lord, in my community, where in the rest of the country crime is down 5 to 7%, it's down 20% here. I'm adding this, guys, in Fulton County, which I'm not going to say anything. Let me just keep reading. Never mind, Lord, that homicides are down in Atlanta by 20%. Is there something about me, Lord, that makes me still unqualified? God responds, child, pray for those. They can't see what I've qualified. Wait, God, I'm going to slow down here. It's your hard-headed child. I told you I don't want to pray for them. I'm tired of being treated cruelly. Pray for them anyway, child. Pray for their hearts. Pray for their souls. I qualified you. I qualified your imperfect, flawed self. I saw you in every hour. Do my work. Ignore the distractions. That, ladies and gentlemen, was Fani Willis's speech that I just read to you, dramatized for effect. This is in this Court of Appeals document. Let's continue. 2 weeks later, a New York Times bestseller was released about Fani Willis and the ongoing case depicting Fani Willis as the hard-charging prosecutor. This is the book called Find Me the Votes, a hard-changing Georgia prosecutor, a rogue president, and the plot to steal an American election. It was published this year, 2024. Find Me the Votes. Knowing this book would be published before trial, according to the authors, Willis sat down for multiple interviews, gave significant access and time, and granted additional interviews with members of her staff. In those interviews, Willis thrusted into the public forefront allegations of racism against her and her office by telling the authors that since her office had opened the case, the comments were always racist. Steve put that in parentheses here. Fani feels that anytime that people made comments about the Fulton County District Attorney's Office, that the comments were always racist. I understand why he put that in italics or parentheses. Willis disclosed racist comments, threats of violence, and highlighted her need for enhanced security due to this case. Willis again invoked God as her ally, stating that she had God's protection and direction in this prosecution. Having publicly cascaded the defendants as racists and aligned herself with God, Willis began her efforts to conceal from the tribunal the full nature of her conduct. On February 2nd, 2024, Willis opposed Roman's motion with an affidavit from Wade that falsely averred their romantic relationship, and she allegedly lied in this document, and she said that their relationship didn't start until 2022. And two later testified it began in April. Overwhelming evidence proved that this was false. For example, 2 Chainz, Robin Yurty, close friend and former employee, testified that Willis's romantic relationship with Wade actually started in 2019, 3 years later. Willis said that it started 3 years later. Robin Yurti also said that she personally witnessed the two acting as a couple and that there was no doubt that it began before Wade was hired. Yurti was corroborated by text messages sent to Roman's attorney by one, here we go, Terrence Bradley, a longtime friend and former law partner of Wade, which confirmed that the relationship absolutely started in 2019 when Willis was a judge in South Fulton. That evidence was further corroborated by defense analysis of Wade's cell phone records. These records established that before Willis hired Wade, his phone was in the general location of Fani's apartment on at least 35 occasions. 35 for the cheap seats in the back, 35 for the cheap seats in the front, 35 occasions, including at least 2 overnight visits. 11 months of cell phone records prove that during the period that Willis and Wade claimed not to be romantically involved, that there were over 2,073 phone calls between them, 9,792 text messages between them, on average of 6 calls and 29 texts per day. I haven't looked at this case in so long, but guys, that's a lot of conversing. There's a lot of conversing. This document is like a book. Let's go back in. Unable to provide receipts, credit card, or bank statements demonstrating Willis had expenses to offset the $17,000 paid by Wade, Willis and Wade testified to a wholly unsupported explanation of cash repayments. Unable to produce any records of withdrawals, deposits, or discussions of repayments, Willis testified that she kept large amounts of cash in her home, which she built up over the years by occasionally going to Publix and getting cash back, and by taking cash from her campaign account, appearing to violate campaign finance laws. Both were barred attorneys, and Willis, as an elected constitutional officer, had reporting requirements to track and disclose any expenditure on her behalf that exceeded $100 in a year. Nevertheless, in 2022, Willis falsely certified that she received no gifts or benefits in a yearly aggregate of $100. All right, now let's talk about the court procedure. Those are the facts that all of this is centered on. On August 14th, 2023, a Fulton County grand jury returned an indictment charging President Trump with violating several state laws, including racketeering. President Trump has denied the allegations, entered a not guilty plea, and invoked his right to a jury trial. You know what's so crazy today? Is like, I remember the day he got indicted and being down here. So that August last year. He's here today. He's in Fulton County today for the debate. Weird. So weird how stuff like that happens. Let's keep going. On January 8th, Roman moved to dismiss as a fatally defective and to disqualify Willis, her office, and Wade from further prosecution. On January 12th, the trial court notified the parties of its intent to hold a hearing. 2 days later, Fani had the speech. This was the MLK holiday. Willis delivered a prepared, racially charged, televised speech that aspersed the defendants and their counsel. So basically, she came after the defendants and their lawyers. Following Fani's church speech, President Trump adopted Roman's motion and supplemented with new arguments that Willis's extrajudicial speech was a calculated effort to foment racial bias into the case that violated Rule 3.8 of the Georgia Rules of Professional Conduct. Augmenting the grounds for disqualification, President Trump took the position that Willis's speech was forensic misconduct. And you might hear this a lot from those. I don't know if you guys remember this, but we talked a lot about this case here, Williams v. State. It's a 1988 case. It comes up a lot. The trial court held 4 hearings on the motion to disqualify. 3 were evidentiary. The trial court heard testimony from Yearty, Bradley, Wade, Nathan Wade himself, D.A. Willis, Governor Barnes, and John Floyd, Fani's father, and Austin Dabney, former associate. He was a lawyer that worked for both Terrence and Nathan's law firm. On March 15, the trial court entered an order granting in part and denying in part the disqualification motion. The order held that the defendants failed to prove an actual conflict of interest, but had proven the appearance of impropriety. That's what this is about. That's why this document is in front of the Supreme Court. Sorry, appeals court in Georgia. I keep getting confused with YoungThug. It's here because although Judge McAfee said, hey, it's not enough for the conflict of interest, but we do see the appearance of impropriety. I will give you guys that. That's what Judge McAfee chose to do. To remedy this appearance, the order proposed a forced election. Willis and her office to step aside, or Wade must step aside. The trial court criticized Willis's behavior in testifying as unprofessional and described her actions as tremendous lapse in judgment over which the odor of mendacity lingers. The trial court labeled the cash payments as unusual and stated the lack of supporting documentation as understandably concerning, and held that there existed a financial cloud of impropriety. Now, that's 1, 2, 3, 4, 5 quotes that Judge McAfee actually wrote in his opinion that Boots pulled out there. That's actually pretty brilliant. Stopping just short of calling their cash payment testimony an outright fabrication, the court half-heartedly said it was not so incredible as to be inherently unbelievable. So here, Judge McAfee doesn't believe that Nathan nor Fani were telling the truth. He's telling you. That's why Boots pulled out five quotes and then continued to mention, hey guys, this is not believable. The order found a need to dissipate the potential untruthfulness over the proceedings as a direct result of Willis's and Wade's actions. It noted that reasonable questions about whether the district attorney and her hand-selected, lead senior assistant district attorney, whatever, prosecutor title that he had, testified untruthfully about the timing of their relationship further underpinned the finding of the appearance of impropriety and the need to make proportional efforts to cure it. Despite acknowledging that courts have an independent interest in ensuring that criminal trials are conducted with ethical standards of the profession and the legal proceedings appear fair to those who observe them, the trial court punted Willis numerous legal and ethical violations to other forums and authorities such as the General Assembly, the Georgia State Ethics Commission, the Georgia State Bar, the Fulton County Board of Commissioners, and the voters of Fulton County to offer feedback of any other questions that linger. That's bad, guys. Boots just came at Judge McAfee. He said you were being soft and you were trying to punt the ball. You're trying to pass the ball to other people. You wanted other people. You wanted all these other government bodies to weigh in. You should have weighed in. You should have stopped it. Oh, Boots is cold. I keep calling him Boots. You guys are like, why do you keep calling Steve Say It Out Boots? Everybody calls him the pit bull. He would wear cowboy boots to these proceedings in a full suit, and I thought that was like different. I don't see that in the North. I don't see cowboy boots in general. So I was just like, wow. And they're nice. Like they were like baby blue and suede. And I was like, look at his boots. Check out Boots. Anywho, on forensic misconduct, the order expressly found that Fani's extrajudicial speech was legally improper and not inadvertent. It then issued Willis a stark warning. The time may well have arrived for a gag order to prohibit the state from mentioning the case in any public forum to prevent pretrial publicity. He was going to gag Fani. It was a warning. McAfee never did it. He didn't do it. But in fairness, this appeal was filed immediately and right away. So he really didn't have time to do it, but he warned her against it. This was filed mid-March, and she did not make statements for a few weeks. Then Easter came. And Boots was sitting there watching and reposting from Twitter. And then he was watching Nathan and reposting from Twitter and watching every single time they talked about it. So interesting stuff, but they were definitely watching what was going on. Despite its findings, with all but acknowledged forensic misconduct, the trial court refused to disqualify based on the restricted application of Williams v. State. Remember that 1988 case I keep telling you guys about? The order construed Williams as a limited holding, restricted Williams to its fact, and construed forensic misconduct to only reach extrajudicial statements that expressly comment the defendant's guilt. So essentially what they're saying here is McAfee did not apply that case correctly to the facts that were in front of them. They're using it as a base because whenever you have an argument, you have to use a precedent, a case that has happened in Georgia history before, and see how it applies to this. Specifically, what they're looking for is the definition of forensic misconduct. What does it mean? What did it mean in 1988? And what does it mean in 2024? What does it mean? And how does it apply in 2024? So that's what Boots is saying. And this is argument one. I'm going to skip ahead, guys, because we've been going for a little bit. And, I also want to make time just in case this debate does happen. We want to be ready for y'all. But the trial court, and this is a quote from the trial court. I'm not going to say exactly what Judge McAfee had mentioned. However, on March 18th, the defendants jointly and timely moved for a certificate of review, which Judge McAfee granted. On May 8th, this court granted the application for an interlocutory appeal. On May 16th, President Trump timely filed a notice of appeal to the Court of Appeals of Georgia. This briefing follows. So that was the first argument. So the first argument was a few pages long, and he focused on not the church speech, it was up here. I just want to give you guys the correct heading. Sorry about that. The procedural background. So we just went through the procedural things, everything that's happened that Judge McAfee ruled upon, and everything that's happened to put this in front of the Court of Appeals. So now, Court of Appeals, let's talk about what Judge McAfee did wrong. Number one, he made a mistake when he talked about the standard for forensic misconduct. Under Georgia law, it prohibits a judge from disqualifying prosecutors for intentional and deliberate violations of the Georgia rules of professional misconduct, right? President Trump preserved his challenge to the Superior Court's construction and application of the forensic misconduct legal standard by timely moving the court below to disqualify the prosecution based on forensic misconduct. That's mistake number one. Two, Judge McAfee made a mistake in failing to disqualify both prosecutors, both Nathan and Fani, not either or, both, Willis and Wade, upon finding the prosecution was encumbered by appearance of impropriety. And Boots is saying there, you said that there was an appearance of impropriety. You didn't disqualify both, you disqualified one. Both should have went down. So that's what they're arguing here. Next, the trial court made a mistake in refusing to dismiss for the prosecutorial misconduct outlined below. And then now they talk about the standard of review. So this is going to get into the legalese, guys. I don't think y'all need to know that. They want to go back in time and find the cases that talk about how to correctly, here's what Judge McAfee should have done. Here's how to correctly apply the legal standard for forensic misconduct. So I'm going to skip through all of that. Now we get into his arguments a little bit more, and he has citations in here. Okay, so I've kind of gone through this. We talked about the forensic misconduct, so I'm not going to do it again because that's a little boring. But he does have a quote from Fani Willis where she says, if I were to comment on any open case, it would be a reason to conflict my office out. Ooh, Boots! Oh, man. He said, emphasis supplied. He said, by restricting Williams to its fact and refusing to unequivocally disqualify, the trial court abused its discretion in two ways. One, Judge McAfee excluded Willis' knowing and intentional prosecutorial misconduct and violations of the Georgia Rules of Professional Conduct. And two, he truncated its factual analysis of whether Willis's challenged remarks showed a calculated plan to prejudice the defendants. Same thing, guys. So sometimes you will have arguments within arguments. And this is an example of that. I'm not going to go too far into his arguments because that's where we are. You know, I'm not going to go too far into them. But he has two arguments right here within one argument, right? So he's saying, you know, Judge McAfee didn't apply the Williams case correctly. We already know that. And he's going to argue why. He has other cases that he should have used instead. But do you see how this can be like 3 or 4 pages just on that? I think we're on 5 or 6 pages just on that. That's why this brief is 64 pages. Second, the trial court truncated the analysis of whether Fani's misconduct was a part of a plan. To disqualify, the Williams case directs the court to examine whether the prosecutor's statements were inadvertent or part of a calculated plan. Meaning, did Fani plan that out when she said what she said publicly? Did she plan it out? Is this something that they sat down and calculated and did together? He's going to talk about it here. And he's looking at forensic misconduct again, the appearance of impropriety. Her personal motive was material. Wow, he's going in. He also says that Fani had a pattern of egregious comments present here, may be necessary to illuminate the plan in circumstances where the motive is unclear and the comments are unplanned. He's saying that didn't exist here. At the end of the spectrum, Fani delivered a prepared speech with clear intent to malign the defendants for personal and political gain. And I think he's going to keep going in on that. He talks about the Find Me the Votes book, ordained by God. We went through that. The racial aspect, we went through that. I'm not going to read it to y'all again. Like, I read you the full church speech with emphasis. Then he talks about the extrajudicial statements with the media that Fani made on her opinion of the defendant's guilt, because she's not supposed to do that. Oh, this is good. The trial court failed to consider how Fani's actions throughout the case evinced a calculated plan. Just 2 days after announcing the launch of her investigation, Willis sat down with primetime interview with Rachel Maddow on MSNBC. By March of 23, some 6 months prior to the indictment, Willis had given approximately 40 interviews with at least 14 media agencies, and most had national audiences. Woo-wee! Boots is coming at her. He's just like, Boots's office watched every single interview she did. They counted. They're like, oh, you're on TV again? You're on TV again? They've been watching. This is new, but it's good. Willis had frequently spoken publicly, often on primetime national television, using phrases as fake electors to intimidate the defendant's guilt, not for a legitimate law enforcement purpose, but instead to prejudice the defendants for personal and political gain. For example, among other topics, Willis publicly, while speaking with national press, opined about President Trump's supposed mens rea, commenting that his conduct was criminal and illegal, and said that people are facing prison sentences, lambasted the defendants, and repeatedly interjected her race for the obvious purpose of prejudicing the jury pool. Oh, man. After twice being reprimanded, being disqualified due to her actions creating actual conflict of interest, and being warned that the time may well have arrived for a gag order, Willis continues to turn a blind eye to the court's admonitions and deliberately violates Rule 3.8 to this day. Oh, man. Look at who, guys, look at this. These are called footnotes. I'm not going to read them to you, but they have every single freaking interview with links to what she said and what she did right here. Look at this one. It says, the following Friday, poking at the court's order, Fani said, it's hard out here always having to prove yourself 2 or 3 times. Recently, they tell me they don't like me to talk about race. Well, I'm going to talk about it anyway. Oh, look at this one. On May 6th, with Willis sitting directly in front of and agreeing with Reverend Motley, one of her religious supporters, she referred to President Trump as the Florida man with the resources of hell behind him, who is saturated with evil. I don't care how many times they threaten me. I will leave here knowing I'm doing God's work. Oh. 2 weeks ago, Willis said she is thriving despite the attacks and being cited, being attacked and over-sexualized as a Black woman doing her job. See, I'm so tired of hearing these idiots call me. Ooh, I'm so tired of these idiots calling me or pronouncing my name as Fani in a way to attempt to humiliate me because, like silly schoolboys, the name reminds them of a woman's rear end or her behind. Oh, gosh. Anywho, he talks about Find Me the Votes, the book. He talks about the hearing conduct, the false affidavit, and the false testimony where she attempted to conceal her misconduct. Basically, they're saying that the relationship started before and they caught them in the lie. And that was submitted in a false affidavit. And if you're a DA, like you're not supposed to lie in an affidavit. You're not supposed to do that. Oh, so this case is a whole mess. I already have a headache and we just started. How long have we been streaming? An hour and 48 minutes. I already have a headache. The state claimed that the analysis did nothing more than demonstrate that Wade's telephone was located where, so they denied it. And they were like, oh yeah, Nathan Wade was around a place, a multiple mile radius where residences, bars, restaurants, nightclubs are located, leaving out the fact that most businesses are closed overnight, even though he was there overnight. He was. The state failed to explain why Wade would have called the elected DA for 40 minutes while on the way to the area in the middle of the night, or why Wade texted Willis at 4:20 a.m. once arriving home, as if he was in the area for some reason unrelated to visiting Fani. There was nothing to explain. Wade was visiting Willis. Oh man, we're not even going to talk about Cobb County ADA Yeager, who likewise told by Bradley about the beginning date of the relationship. So you have more people. Another ADA from another county witnessed Willis, instruct Bradley not to speak to anyone about her relationship with Wade. The trial court refused to consider Yeager's testimony, but the mounting evidence of evasive tactics and impeached testimony support a calculated plan that required disqualification. Yeah, I'm going to be honest, guys. I'm done reading it. Like, there's a lot here. I think it is undoubtedly known these guys had a relationship. Whether they wanted to hide it or not, fine. That's on you. But I think we can all discern that this thing existed. It did. It did. Now, it's resurfacing now. It's likely that Fani's team is going to issue their argument on the things that Boots is talking about here. They're going to talk about that there probably wasn't an appearance of impropriety, that the judge did make a good decision. They have a right to respond. But at the end of the day, we're not going to see anything come out of this until the fall of this year. So sitting in Fulton County right now, in the middle of debate day that we may or may not see on YouTube because CNN is being mean. Let's come to you guys in the chat. Shout out to Anna with the $9.99 super. She says, I got my notifications on now. Hope you're having a wonderful day. Also, isn't commentary on the political debate covered under fair use? It is, but CNN has mentioned that they're going to strike. They're going to strike us all. There is a big creator. His name is Meet Kevin. He has sued CNN for doing this. So we're all just kind of watching right now to see if this could be covered. Because again, this is really about community. Like, we spend so much time with you guys. It would be amazing to watch a presidential debate with our communities here on the interwebs. So thank you, Anna. I really appreciate you. Shout out to FFS. Enunciate, for fuck's sake. I'm so done with you. But with $4.99, he says, I'm late to the shit show. I was in an ex parte meeting with dishonorable Glanville. What did I miss? I'm pretty sure you've caught up by now because I'm reading the super chats super late. And I see that you left at 4:49, and that was almost 2 hours ago. So I think you're good. Shout out to Anna P. again. They're afraid of people watching commentators cover it and fact-checking Biden in real time. Yes, Anna. Anna, I think this is what it is. And CNN's ratings are so low, they're desperate to force people to watch CNN. That's what it's likely to be. They are allowing Fox, MSNBC, the other major outlets to stream it. So technically, we could probably go over there and stream their stuff. But because the feed is coming from CNN, CNN is making it super abundantly clear that they're going to sue anybody that uses it. It's so silly. And really sad. Shout out to Audrey with $4.99. She says, this is crazy, and we're coming on the 4th of July. I know, it's next week. It's next week. Shout out to MG. Wow, guys. MG gifted 10 AV memberships. Guys, if you got a membership from MG, please say thank you to her. I know you guys did it. I'm pretty sure you did. I'm super late to the party and catching up with y'all in the chat. But wow, MG, thank you. That was very generous of you. And again, I'm building my community up. We talk about some of the unsavory topics and the popular topics too. But I just thought it was an interesting day here. It's finally stopped raining. So interesting day. But MG, thank you so much for helping grow my community. And congratulations to those folks that got memberships. Please tell her thank you. That's super sweet. Shout out to FFS, enunciate, for fuck's sake. Bro hasn't learned to not fucking self-snitch. My guy, you just try to catch another indictment. Yeah, I haven't posted Woody's thing, but I need to do a whole video on like Woody talking as a witness that's currently sworn in. I think that's why he deleted the message, but you guys screenshotted it and sent it to me, so thank you. Shout out to Question Everything with $2 who says Biden is going to shit his pants again. I hope he doesn't. I hope he doesn't. Mr. Told You, thank you so much with the $10. It says, shout out to that helper gal. Thank you. Thank you. Mr. Told You. Shout out to Bunny Mom with the $4.99. It says, I seen somewhere that CNN said that they are going to mute Trump's mic. Yes, they are going to do it. They have already put the technology in where they have the ability to mute both of them. But they have mentioned that they will do this tonight. So they're going to give everybody an allotted time to respond. But like how that's the epitome of censorship. He's not going to be able to respond. But like, I think that they've seen the 2016 debates, the 2020 debates, and now we're in 2024. So I'm pretty sure they're going to use not even use the excuse. I think that they're attempting to be biased. Like there's even a video of them talking about how the debates are going to run, and they talk about the technology in the Atlanta office here and how that technology functions. So Bunny Mom, yeah, is crazy, but you're right. That is fact checked and accurate. Shout out to Kayla with $19.99 who says, is Fox News streaming? Also, CNN needs the ratings. Love this channel and appreciate all you and TLA do for us ghosties. Thank you so much, Kayla. That was a very, very sweet super chat and very generous of you. They do need the ratings from what we can see. They are headquartered here in Atlanta, and I think that's why the debate is happening here in their headquarters. Is Fox News streaming? From what I've heard and seen today, the answer is yes. But remember, everybody is we're all using CNN's feed. So everyone will get, we'll all get slapped on the hand if we use it. So lots of corporate power there. Shout out to Dear Whoa Christian with the $5. Thank you so much. He says, thanks for the update, AV. Looking forward to the debate and multiple recaps. YSL is also going to be a trip. Keep making good content. Let's go. Thank you so much. And guys, if any of the mods have the link to Dear Whoa Christian's channel, check him out. Great content creator here in Atlanta as well, in the Georgia area, and has been covering this case from top to bottom. Check him out. Thank you so much. Shout out to C. Cooper, who's become a member. Welcome, C. You're going to love it here. I know you will. I know you will. Shout out to you. Shout out to Sherry with the $12 who says, I can't watch without you, AV. Yeah. And that's the thing. Like, you guys know. Like, you know, if it's me and TLA and if we're doing this on his, like, if we're doing this and watching, you guys know it would be a good time. You know it would be fun. So I'm bummed. I'm really like disappointed that we can't like stream this thing. And it's like, you know, our community, we cut up, we have a good time. So it's like, I'm really disappointed that we can't watch this together as a group. So thank you. Thank you, Sherry. I really appreciate you. Shout out to Army Nurse with the $20. She said, we need Trump back. What's the alternative? I know a lot of people don't like him. I know he's made some mistakes. But like, what is Biden doing? Like, I'm always like, Joey, Uncle Joe. Like, huh? Okay, is he up? Like, what is Uncle Joe doing? Thank you so much, Army Nurse. I appreciate you. Shout out to D with the $1.99 who says Communist News Network equals CNN. And then he says the pit bull in a rage. He ain't playing. Shout out to Tapiz with $5. Says much love to AV in the chat. Thank you so much. I love our community so much. The one lo-fi. Look at Terica. You know, I was listening to you on the plane today. I was listening to you this morning on the plane. I fell asleep listening to your lo-fi music. Guys, check out Terica, another content creator in our space. She does lo-fi music. If you are doing laundry, if you are cleaning, if you just want to listen to music as you're doing a task, I highly recommend you check out her channel. Huge supporter of me, huge supporter of the lead attorney. She is amazing. Check it out if you're looking for lo-fi beats. Enunciate for fuck's sake. Enunciate for fuck's sake is back. And he says it's not that big. That's what she said. I don't remember. Did I say something like that? Shout out to Mama with $5. She says, can you do a recap? I didn't get notified with notification by YouTube. What motion are you reading? Thank you, Mama. So I love when you guys ask me to do that. That means you like it. So we are reading a motion from Steve Sadow. He is the attorney for Donald Trump and the Georgia election interference case. This was the whole thing with Fani Willis and Nathan Wade their relationship information came out to everyone. But it seemed as if they were both financially benefiting from the relationship while they were looking at this election interference case. The defendants in that case brought it up. They didn't think it was appropriate. This has been ongoing since January. This is the first document for the appeal that was not first, but at least the first important document filed on appeal, because this shows what the arguments are. It is very likely that Fani's team is working on a response for this right now, and we could see that in the next few days, or we could see that closer to appeals time in the fall. So that's what's happening. And thank you so much, Mama, for asking. Kim, welcome. You're our new YouTube member. We got a lot of perks coming for you guys, so really appreciate you. FFS says, in the famous words of 50 Cent, I'm gonna need my money by Monday. Just a meme of Cassie. Shout out to CP30, $9. Thank you so much. $9.99. It says, seemed Georgia Supreme Court dismissed writ. Yes, I just I talked about that. After I get off with you guys, I will chop this up in timestamps as usual, so you can go to those parts. But one of you guys let me know that the Georgia Supreme Court denied the writ of mandamus in the YoungThug case. That made me really sad. But yes, I will do a follow-up for y'all and talk about that a little bit more. The International Quiet Storm from the West Coast. How are you doing, brother? He sends $10 and says, who has the time? Who has time throughout the day to converse that much? Fani and Nathan need to touch grass and not each other. I mean, yeah. They texted each other a lot. A ton throughout the day. A ton. Shout out to Captain Jones, CPT Jones, $20. In your opinion, how should Fani and Nathan have dated not to get in trouble? If possible, what should they have done differently to be together and not get in trouble? This is actually a thoughtful question. Thank you for asking, Thoughtful Jones. And that's one thing that I want to try to do a little bit more here on this channel. People are just like, you're biased. You always pick one side. Like, you don't, they think that I don't call it down the middle fairly enough. So this is an excellent question for us to be able to tackle that. Now, how do they do it differently? Well, I think Nathan should have been divorced before they started dating each other, but we know that that doesn't always happen. Clearly here, they were dating each other before that happened. Now, she couldn't really hire him, because if they were in a relationship, the relationships in the workplace are frowned upon, especially in the law. Like if you're a husband and a wife and you have your own independent law firm, that's fine. We see Ashley Merchant and her husband, they have their own law firm. You see Brian Steele and his wife, they have their own law firm. They're both partners. That's different. You see a lot of families that are together, and that's different. Here, Fani has a very important job. She has to be very careful with the decisions that she makes. And I would have loved to see her be a little bit more careful with this, especially being a woman with such a high profile role. I think that they tried in a sense, but not hard enough. And what they could have done differently is, if Nathan was fully divorced, I think that wouldn't have had too big of a public scrutiny on it. But like, she didn't have to involve him in this case. Like I said, Captain Jones, she could have hired anyone. You could have dated this guy and not been in the public limelight if you really wanted to be with him. He shouldn't have had this job if he was unqualified. And she did say that he's had some criminal experience, but to prosecute a president, there are other people out there that are more tenured in legal matters like this. I think that she could have hired somebody else. And if they wanted to maintain it, fine, do that stuff over there. Just don't do it when it comes to, high profile cases like this. Thank you, Captain Jones. Hi, Lucy. She drops 20. Trainwreck Entertainment. Guys, please check out Trainwreck Entertainment. This is a husband and wife duo team. They are amazing and crushing it. They cover more localized cases. And I think you guys would would likely like watching them. They have a favorite judge that they're covering right now, and they do such a great job. Check them out. If one of the mods are in the chat, you drop their channel, that'd be fantastic. It says, AV, sorry I'm late. Just wanted to let you know how much I appreciate you. Also, I'm loving my Woody merch. Great work covering the circus ops. I mean court. Guys, again, we are doing the YSL trial. I have my Woody merch. This is a reject shirt, but we do have What You Mean t-shirts that are available for purchase right now. There are water bottles, which Lucy has purchased. There's I think there's a notebook, there's a hat, there's a phone holder, and we're doing this in honor of the trial. We know that the trial is going to be around for a little while, so check it out. It's available. I will put the link in the description box below for you guys to check out the merch if you're interested. But thank you so much, Lucy. Appreciate you. And again, if you guys could check her out, that'd be great. Shout out to Ellen, who's become a member. Welcome, Ellen. Welcome. You're going to love it here. You're going to love it here. Hi, Edwin. Edwin has also become a member. Welcome to the community, my friend. Also, you will love it here. It's going to be great. Shout out to D. Marie with the $10 super sticker. Thank you, D. Marie. The one Lo-Fi Terica. She says, AV, check your Twitter. Super, super amazing of you and thoughtful of you, Terica. You know, you can always send me a message. You don't have to send a super for that. I'm looking at my Twitter. I will look at it later, Terica. I don't see anything live right now. It looks current. Did you send me a DM or a mention? Okay, I'll check that out, Terica. But thanks again. Thanks again. I will look at that. And guys, sorry, I'm young old. Like I'm millennial old. Like I should be able to get to these things faster, but I'm getting there. Shout out to MMCS, who has become a new member. Welcome, MMCS. Kavas Moose 199 says CNN is so Clinton News Network. I mean, it is, it could be. FFS says, hypothetically speaking, if I were to stream it on here, what the F can they actually do? Could they sue me if I have nothing for them to get? Hypothetically saying, yes, they will. They will. And, you know, for creators, it's much more of a bigger threat, guys, because, you know, I do this full time. This is enabling me to study for the bar exam full time. YouTube, I love to do this work and I love hanging out with you guys. I'm passionate about this and I'm actually getting this degree so I can do more of this in addition to practicing law on the side, right? But when a corporation, because YouTubers are essentially independent people, like we're independent business owners in a sense. So if you are an independent business owner, let's say, you know, we'll use Meet Kevin. Meet Kevin's like 3 million subscribers or 2.9, I don't know. He has millions. He's an independent entity. And if he wants to stream this or talk about this, CNN is threatening his business. They're like, oh, get out of here. No, you're not talking about that debate. So that's the unfortunate part. But like, if you do this as a job, these are our jobs. We can't report to you guys. So for you, hypothetically speaking, if you did it, they would strike your channel. There's something called copyright strikes. You get a copyright strike for using material that somebody doesn't want you to use and your channel's gone. You don't make money. Hope that answers the question. D. Marie Carter with the $10 says, aloha from I don't know how to say that, but I know it's in Hawaii. It says, AV, you are going to make my precious, make my. We need to have a lesson to teach me how to say things in Hawaiian. Like I helped a family member pick a name for another child in our family, and it's a Hawaiian name. So I would love to learn more about your culture, but aloha. So good to see you here. Thank you so much. Shout out to Valerie, who has become a member. All right, guys, I'm going to go to wrap it up. Let me just check out some Cash Apps, make sure I've captured all of them. But this was super fun. I really wanted for us to watch this debate tonight. Seriously wanted us to do it, but I'm so sad that we couldn't. Shout out to Eve. I will say Eve. She sends me $25. She says, You look, my fam, keep exposing ish. Yeah, no, I'm going to keep looking. I'm going to keep looking. I'm going to keep looking. So that's going to be great. Shout out to Juanita, who sends me $15. She says, thank you. Thank you, Juanita. I really appreciate you, sis. And then shout out to Ellen with $7. No comment, no question, pure love of the game. All right, guys, keep an eye on your notifications tonight. I don't know what's going to happen. We are going to watch the interwebs. If we can stream tonight, we will. All right? Know that. If you don't see us, then you know why. Right? At least today. Tomorrow is Friday. There's plenty of stuff going on. So if you don't see us back tonight, you will certainly see us tomorrow on one of the sides. But thank you so much for hanging out with me this afternoon and learning more about the Steve Sadow document that was scathing. But I hope you learned something today, and leave a like or a comment if you're watching this on replay. What did you think about the document? How do you feel about the situation? Let me know what you guys think in the comment section below. I will see you in the next one. Stay safe out there. Bye.